I call the Honourable David Parker.
Thank you, Mr Speaker. I rise to support the third reading of the New Zealand Security Intelligence Service Amendment Bill and the allied bill, the Crimes Amendment Bill number 3. The Labour Party will be supporting both of these bills. Mr Speaker, I want to talk briefly about the balance that we try and strike in this Parliament between the rights of the individual and the rights of the community. This bill strikes at the intersection of those two competing interests. We all know in New Zealand that we try to protect against the inappropriate erosion of our civil liberties in New Zealand. Those civil liberties include the right to go about our business without intrusion by the state or arms of the state, except where that is strictly necessary. There are exceptions made in various areas of the law. For example, if there's an allegation of some form of criminal activity, then an arm of the state has the right to apply to the court for various ways of intervening through a warrant process, so that people who are alleged or being investigated for crimes can have their affairs looked at a bit more closely. That's an involvement, and that involves an intrusion of the state, and when there's ever a suggestion that the rights of the state to intrude on the private lives should be extended in some ways, there is appropriate scrutiny made by various arms of civil society, the media, the law society, civil liberty groups, private individuals, to name but a few, all stand up and say, hey, we should look at these things pretty seriously before we confer additional rights. The problem that we've had in respect of the process that has been adopted in respect of this bill that we're now considering is that process is not as open as it could have been. I'm informed that if you look at the history of the Security Intelligence Service legislation, that the last time the bill was amended, there was a commitment to openness of process by the then government under the leadership of the then Prime Minister, the Right Honourable Jenny Shipley, who ensured that to the extent possible submissions on the bill could be heard in public. If there was any part of those that evidence that was to be given in respect of, if there was any part of those submissions that was sensitive, that people thought should be secret, then they could apply to the Select Committee, and that particular part of the submission could, if the Select Committee thought appropriate, be heard in secret. Now, the government, in respect of this piece of legislation, chose a different course. They actually chose the opposite. They actually said, instead of having a presumption that we should do this openly, they decided in advance that all submissions should be heard in secret. That is an issue that the Labour Party, together with other parties, including the Greens, have been critical of, because there was no need for that secrecy in a general sense. And that level of secrecy means that people are less well informed and more suspicious of what we are doing in Parliament than would otherwise be the case. I have no doubt that most of the submissions that were heard by the Select Committee could have been heard in public. If they were heard in public, submitters could hear what each other was saying to the Select Committee. Members of the Fourth Estate would have been able to listen to some of the things that were being said by submitters. Submitters would both have greater confidence in that process, but also the Fourth Estate would readily have been able to discern for themselves who was tilting at windmills and what concerns were real and should be paid real attention by the Select Committee. But because of the process that the government, under the Honourable John Key, chose in this instance, there was no opportunity to have those submissions heard in public, and as a consequence, the standard of debate that we've had in civil society around this bill is worse than it would otherwise have been. I think that is lamentable, and notwithstanding the fact that we support the legislation as being a fair update of the powers of the Security Intelligence Service, I do want to put on record again that I think that the process was poor, that we have a number of occasions in this Parliament seen poor process on the part of the national government, and it undermines public confidence in institutions that we ought to be doing more to maintain public confidence in. In respect of the merits of the changes that are made, Mr Speaker, the main changes have been well summarised by the Attorney, and I won't go through all of the points that he made. Suffice it to say that in main, this updates the suite of technologies that can be utilised by the Security Intelligence Service. Whenever there is an extension to those powers, we should be rightly suspicious in this Parliament that we are not conferring unnecessarily broad powers and therefore unnecessarily intruding into the private lives of New Zealanders or creating some arm of the state that's got inappropriate powers. We also need to have regard to the fact that if powers were if technologies weren't thought of when these original pieces of legislation were first passed, there are instances where there are actually unregulated powers that the Security Intelligence Service might be able to exercise without the sorts of controls that we have through this bill. And that's something that we uncovered when we were looking at police powers of search and surveillance earlier in the year on the Justice Select Committee. We actually discovered that far from necessarily increasing the power of police in all cases, in some cases we were regulating what were then unregulated powers because those powers weren't even covered by the original legislation. Mr. Speaker, I for one take considerable heart that we do have checks and balances on the conduct by the Security Intelligence Service of their duties through oversight by the Prime Minister, who has to sign off on warrants. I beg your pardon? On domestic warrants, thank you, Mr. Chevelle, has to sign off on domestic warrants. And perhaps more importantly, we have the Commissioner of Security, the Commissioner who oversees warrants, who is by law required to be a former High Court judge. And in this regard, I'm happy to stand on record and say that I'm very proud of the fact that in New Zealand we have a long tradition of a non-corrupt judiciary. Our High Court and Upper Courts are as good as any in the world. We have no history of corruption in our higher courts, of which I'm aware, and we only have the very occasional incident of misconduct in lower courts. Indeed, I would think that our system of a non-corrupt judiciary there is no better example anywhere in the world. Therefore, when we appoint a former High Court judge to oversee what is happening in the Security Intelligence Service, we can be confident that we are appointing someone of integrity who will go about their duties responsibly with a view to protecting the traditions that we hold dear in New Zealand, which is that those traditions are that we don't have the equivalent of we don't have a Security Intelligence Service that overreaches its mandate and turns into a spying organisation on New Zealanders in a way which is not appropriate. So, Mr. Speaker, the other point that I would like to reinforce that the Attorney General also made reference to was the principles that have been inserted into the Act. The principles were inserted at the suggestion of, amongst others, the Human Rights Commissioner, who suggested that the Act make it clear that when it performs its functions under the Act, the Security Intelligence Service must contribute to keeping New Zealand society secure, independent, free and democratic. It must contribute to the participation of New Zealand in the maintenance of international security, and it must act in accordance with New Zealand law and all human rights standards recognised by New Zealand law, except to the extent that they are in relation to national security modified by an enactment. The Intelligence Service must act in the discharge of its operational functions independently and impartially, therefore it can't become an arm of political purpose, if you like. It must act with integrity and professionalism, and it must act in a manner that facilitates effective democratic oversight. And perhaps that last point is quite an important one, and that if it points the Commissioner or the Prime Minister, for that matter, were concerned that it was hard to assess whether this service was acting in a manner that facilitates the effective. If those that are responsible for oversight were concerned that they couldn't effectively oversee its operations, then they could have regard to that purpose and principles sections, and they would no doubt say to the Prime Minister that they had concerns, and through that we exercise control. Mr Speaker, with the reservations as to process that I've already enunciated, the Labor Party supports both of these bills.